Hi, Clint Coons here with Anderson Business Advisors, and in this session, I'm going to give you my top 5 mistakes when it comes to using land trusts that are made by real estate investors. You know, so many real estate investors, they want to do this on their own. They want to save a few bucks. They don't want to hire a professional to create their trust for them, or maybe they saw a guru who came into their local RIA and told them, you can do this on your own. Well, I'm not going to dispute that. There are plenty of individuals out there that are competent, they invest in real estate, they're sophisticated enough to put these documents together. But if you make a mistake, then it could all unravel on you. And that's the last thing you want to do, is find out that you didn't do something right when you're putting your trust together, or you didn't set it up the right way from an asset protection standpoint. And then when it's tested, that is, you're involved in a lawsuit, they dismantle it and you're held liable, or you don't get the protections you thought. So let's talk about my 5 top mistakes that I see when it comes to land trusts. Number 1, and these aren't in any particular order, by the way, it's serving as your own trustee. Never serve as your own trustee of your trust. Serve as own trustee. All right, this is one of the mistakes that a lot of people make, because with a land trust, what you're hoping to accomplish, I'd assume, is you want anonymity, number 1. And so if you're the trustee of your own trust, you've just blown one of the major benefits of a land trust, that is keeping your name off title. So when you're the trustee, everyone knows that you are somehow associated with the property. The other reason why you shouldn't be your own trustee of your own trust has to do with the doctrine that's referred to as the Merger Doctrine, which states that if the trustee and the beneficiary are the same individuals, that is, when you create your trust, let's assume you're a single individual and we transfer it into trust where you're the trustee and you're the sole beneficiary, then title merges back into your name as the grantor, and the trust is never looked at as a valid instrument holding title to the property. Now, that's an archaic law doctrine that is sometimes applied in certain cases. So you don't want to be your trustee just to avoid the merger doctrine as well. So don't be your own trustee for anonymity and because of the merger doctrine. The number 2 is using your home address on the tax statements. All right, and this goes with being a trustee. Do not use home address, okay, on tax statements. All right, so this is a great story here. Dennis Hastert. Now, you may know about him from some things that he did wrong on a criminal side. Well, actually, both these are criminal sides, but I'm not going to talk about what happened with supposedly with some underage individuals. But he'd also was brought up on federal corruption charges, because Dennis Hastert passed through this federal funding project to build this freeway through some counties in Illinois. And it just happens that a lot of the property where they're going to push this freeway through was owned by Dennis. Now, he didn't own it outright because that would be a conflict of interest. So what he did is he created a bunch of land trusts to own the property. So he had all these land trusts established like this, owning all this land where they're going to run the freeway through. So what would end up happening is the government would come in and buy this land from him that he picked up for 50% or 30% of what he would sell it to for the government, because obviously once they're going to put a freeway project through there, the land values are going to go up. Now, people started opposed this freeway. So this conservation group and individuals, they didn't want the freeway project to go through. And one individual that was part of this group to block this freeway found out that all of these trusts were held in the name of a trustee. So they used a nominee trustee. Dennis did not serve as his own trustee. So when they looked at these parcels, and it wasn't all the land, but there was some land there, they would see an attorney's name listed here as a trustee. So the property was held in the name of Dewey Cheatham, trustee of the Evergreen Trust, and then Dewey Cheatham, trustee of the 13th Trust, and so forth. And it didn't disclose, of course, the beneficiary. So when someone's looking at these property owners, all they see is that they're held in land trusts and they don't know who's actually behind the trust. Hence, going back to number 1, don't serve as your own trustee. But on one of the trusts, Dennis made a mistake. Because when you transfer title into trust, you have to fill out typically a preliminary change of ownership form with the assessor's office, telling them that here is the trust is now the owner of the property, send all tax statements to this address. And what he did is he used his home address. Actually, it was an address on a property that I believe that his wife owned. And so they were able to track on one of the trusts through the tax statements where they were being sent who the actual owner was, because they pulled up Dennis's name and said, well, why would Mr. Hastert's wife be receiving tax statements on a trust of which Dewey Cheatham is listed as the trustee of a land trust? And that was the thread that began to unravel everything, and they discovered that all of these trusts were owned by Dennis Hastert. And that's what got him brought up on federal corruption charges and actually stopped the freeway project. So I'm not telling you to use a land trust to commit fraud, but I am telling you is that if you're setting up for anonymity purposes, never use your own address. Always set up a P.O. box or something for your tax statements. If you're a client of Anderson, we provide you an address at our Las Vegas office. And so I have clients all over the country, New York, and they're sending their property tax statements to Las Vegas, and then we forward them back onto them so that they can't trace it back to the individual client like they did in this particular situation. Number 3, all right, the third mistake is failure to assign interest. Okay, what do I mean by that? Well, your beneficial interest in your land trust, all right? You don't want to be the beneficial interest holder, because if something happens and the trust is sued, then you're going to be held liable. So you have to assign your interest over to a limited liability company for asset protection. Now watch my other segment on how to assign the beneficial interest of a land trust and see how that's done. But a lot of people who set up trusts miss this crucial third step, or they botch it. And so they end up still being the beneficiary of their trust. And if a lawsuit develops, they're going to get hit and held personally liable. All right, number 4, okay, mistake, informing your lender. The property's encumbered. All right, this is one of the benefits of having a land trust, is that you're able to transfer your property into your trust and it doesn't invoke the due on sale clause of your mortgage. You have the promissory note that you sign with the lender, because it's covered under the Garn-St. Germain Act and public law that a lender cannot accelerate when you've transferred title to property into your grantor trust. Now that's going to be my 5th point here in just a second. So when you set up your land trust and you transfer the property in, you don't need to call up your lender and tell them that you transferred into the trust, because all it's going to do is create confusion for the lender. And it actually could trigger a different type of fee. They may not be able to accelerate your note, but they could hit you with a title transfer fee. I've seen some lenders get real sneaky now, where they put into their agreements that if you transfer title to property to a trust, they can assess you a 1% of the mortgage balance fee for accepting that title transfer. They don't have to do anything on their end. It's just a way to nickel and dime you for more money. So there's no reason to call your lender and inform them of the fact that you've created a land trust. It's only going to create confusion for the lender and possibly create additional costs for you. Now, number 5. The 5th mistake that so many people make is this, referring to their trust as a land trust. All right. In one of my other sessions, I talk about how to name your trust. Well, I discussed in that session, the problems that come up with naming a trust. Well, you do not want to refer to your trust as a land trust unless you have set up a trust in one of those states that actually recognize a land trust by statute. And if you look at my session on whether or not a land trust is valid in your state, I've listed out the law and those states that actually recognize land trust by statute. If you don't live in one of those states, or you're not using a trust in one of those states, never refer to this trust as a land trust, because it's going to create confusion. When you work with an attorney, a lender, CPA, mortgage broker, whatever, if they've never heard of this term before, because you can't expect them to, because if it's not codified in statute, then it's in case law, and they got to be really up on their case law to know about it. And if it's not something that they're working with on a daily basis, then they're typically going to be down on it, and they're going to tell you they do not work in your state. So here's the key word you use. Whenever you're referring to this trust, do not call it a land trust. In fact, I don't even put the word land trust in my document. I always just use the word trust after the name. So if you're going to transfer title into the 7th Street Trust, don't call it 7th Street Land Trust, just call it 7th Street Trust. And watch the session on titling your trust, and that explains it in more detail. But if someone asks you what type of trust you set up, tell them that you set up a grantor trust. Grantor trust. Always refer to it as this. Grantor trust, it's a common trust. It's recognized in all 50 states. In fact, if you have a living trust, which is a very important part of your plan overall, it's an estate planning document, it is also a grantor trust. And so any attorney that's familiar with estate planning is going to be familiar with the term grantor trust. It's a universal term. Call your land trust a grantor trust, and you'll be amazed at the reaction you get from people when you drop the word land out of it. My name is Clint Coons with Anderson Business Advisors.